Good morning, WTOB listeners. This is For the Record with Greenwood Law. I'm Dylan Greenwood, joined with Harold Eustache, and this morning we're going to be talking to you about police interrogations. Before, we've talked to you about Miranda and the implications of your Fifth and your Sixth Amendment rights. Today, what spurs our conversation is something that happened in another state, and that is the state of Illinois. They recently passed a law that made it illegal for members of law enforcement community to lie to minors, those under the age of 18, during police interrogations. And I would imagine that a lot of our listeners might hear that and go,
why would they ever lie?
Yeah. Or, wait, they interrogate people under the age 18? You know, what are you talking about? Police and law enforcement interrogate a lot of people under the age of 18.
Absolutely.
And you can just think here locally, some of the things that have been in the news recently involved a lot of juveniles.
Right.
And when that occurs, it's a common part of a law enforcement investigation to interrogate people. So this is a big deal because it is the first law in the whole entire United States that makes it illegal for police to lie during interrogations. And so part of the reason it came about is because Illinois has a long, nefarious history with coerced admissions leading to wrongful convictions. They recognize that. Like in the law itself, they're like, listen, we understand we have this history. We want to do something to rectify it. Here's our first step in doing so. And it set this up, and I think it is a great thing to look at because police can lie during interrogations. Police can lie when they talk to you. It might have implications, but this is something specifically on the books where it says it is illegal as it relates to a juvenile for them to lie during an interrogation.
I think that's really important because part of the way we view juveniles, I think not just in Illinois but here in North Carolina, is that they do have a different level of ability, to cognitive ability to accept responsibility or understand certain things. And so I think it's a good law. It just, in the fact that, a lot of times in North Carolina, especially, a parent has to be present for these types of interrogations with juveniles. And, if an officer is misrepresenting something or lying about something, that could elicit a confession, especially with, somebody that's impressionable. And then that can lead to a whole lot of other things.
Yeah, I mean, you touched on a great point. Think of all the other aspects of the law where we recognize that juveniles are impressionable or have a reduced capacity. So, for instance, the age of majority, the age of which you can give full consent to any type of sexual act, is the age of 18. There are some nuances there for below that here in the state of North Carolina specifically, but generally speaking, no matter what, it's 18. So we've recognized it there. Also, age 18 is the point in which you can enter into a contract.
Exactly.
You can't do that with a minor. It voids the contract.
Right.
So, we've recognized it in all these other areas. It makes sense that in a police interrogation you would have this because and the thing that's recognized in the law is that wrongful or coerced admissions are a significant part of the reason why wrongful convictions take place. It is estimated that it accounts for at least 30% of the wrongful convictions that happen in this country. And it goes on to talk about how the ability for coercion as it relates to minors is 2 to 3 times more likely as it relates specifically to minors if they are coerced during some sort of interrogation and lied to.
Right, and it just makes sense. Everybody understands as adults that minors are impressionable on some level, especially by adults and especially by an adult in an authority position. And so, and that's why we have, on the flip side, we have laws where if an adult is in an authority position and they take advantage of a minor, we have enhanced penalties.
It's an aggravating thing.
It's an aggravating thing. You're a teacher. You are a gym coach. You're whatever. And so, I mean, I think reciprocally it makes sense for us to acknowledge that way. So, that seems to me very, very reasonable. I think also people would ask, well, police lie in these types of interrogations, and that's part of it, and it's pretty standard, especially if you have different. Let's say there's more than one person that is being investigated. Police may split them up and say, well, this person said something that may or may not be true to the other person to get them to make an admission. That's very, very standard. And if that happens and the person makes the admission, it could be admissible in court. Mm-hmm. So,
I mean, there have been, you hear about those times where they bring someone in for a polygraph and they go through the whole entire polygraph and make them sweat through the polygraph, and they never plug the polygraph in. They tell them that they failed, and then all of a sudden they get all the information in the world from somebody and get them to admit, and they never had a polygraph result to begin with.
Mm-hmm.
So, I mean, you hear all this. We hear it in our job a lot,
mm-hmm.
That the police or law enforcement said something that maybe was misrepresented or was false, and then all of a sudden got them to say something. So a lot of times the way this plays out that we've seen is in traffic stops. You think about it, more often than not, interaction that you're going to have with law enforcement is more likely to happen during a traffic stop than almost anywhere else.
Mm-hmm.
And we hear and even see through Axon video, police body cam, of times in which law enforcement officers tell people that they have to do certain things, or they need to comply in certain ways that they have a constitutional right to say no about. And people go, well, they come to us and they go, well, this is entrapment. They got me to do this. They misrepresented what my rights were. Well, they can do that to a certain extent. And it's incumbent upon you to know your rights. That's why Harold and I are here doing this program, so that people stay informed and understand what's going on and understand what you have the right to say or not to say, or the right to do or what not to do. And this is a big aspect of this. So at any time during an interrogation, you do have the right to counsel at any time. Juveniles specifically in the state of North Carolina actually get told an additional thing. They don't just have the right to counsel, they also have the right to have a parent or guardian present during an interrogation. That's specifically written into the law.
Right.
But this court has recognized that you should stop short, or a police officer cannot tell a juvenile that anyone can be present, because that makes it sound like you could have anybody, and it may not be a person who has your interest in mind. So the thought process there, whether it's a parent, a caregiver, a guardian, a lawyer, or whoever else, they've got your interests at heart during that interrogation to help you out.
On the topic of interrogations, it's something that we deal with a lot, whether that's before a person is charged or sometimes subsequently. But we would recommend that you have an attorney present at these types of interrogations. A lot of times people think, well, I've got nothing to hide. Why would I not just go ahead and openly talk to law enforcement about what I did or didn't do, not realizing that, again, and we've touched on this before in some of our programs, that you're admitting that you were there. You're admitting that, I was there, this happened, but I just didn't do that one thing. But you're still admitting lots of other things that could lead to your culpability. So again, it's just important for you to know your rights and for you to have an attorney present. If that's something that you can do, we'd always advise that to every single person, especially a juvenile. And there have been cases that I've dealt with juveniles where a parent wasn't present, and the interrogation, well, maybe not the entire case, but that interrogation portion was thrown out because there wasn't a parent present, or the juvenile wasn't advised properly. So it's extremely important when interactions with juveniles are different than interactions with adults. From that first interaction all the way through the entire criminal justice system, it's just a whole different thing.
But North Carolina, as it is yet currently, does not have a law similar to Illinois. Illinois is the first state in the whole entire nation to do this. Hopefully more states follow suit. And as I'm aware of, there's not a law pending before our legislature to consider this type of thing in the future. It might come about in the next legislative sessions, but I'm not aware of anything pending. What North Carolina does do, however, is our courts assess the voluntariness of a interrogation or an admission. So they look to see whether or not the product of an interrogation was essentially free and unconstrained choice by the person making it, and then goes on to talk about that a suspect's statement is involuntary or coerced and therefore inadmissible in court when the suspect's will is overborne. So that's a bunch of legalese right there. But how it breaks down really is the easy way to think about it is if it's a coerced interrogation or admission, on one end of the spectrum you have where there's some sort of physical either threat or actual physical thing done to somebody to get them to admit or to make statements during an interrogation. That happened a lot in our history. Right.
I was just thinking that. I mean, this thing of putting laws around interrogation is kind of new-ish. I mean, if you look at a lot of cases from 1900 to 1940 or so, interrogation and enhanced interrogation, physical interrogation was very common in the United States as far as getting these types of admissions through any means.
Yeah, I mean, think about television you watch. Old school detective go in, like Lethal Weapon or something, and Riggs is in there. They grab somebody by the head and they bust them in the table. Now, what are you telling me now? Nah, I mean, you can't do that. I mean, that is coerced. That would not hold up in a court of law at all. And so mental or physical threats can certainly lead to involuntariness. Any type of personal characteristics of the individual. So it's interesting. North Carolina recognizes that if you have reduced capacity, so if you have a low intelligence, a lack of education, anything like that, then that is a factor that is looked at specifically as it relates to whether or not your admission was coerced. So that's interesting if you think about it from the standpoint of a minor that we inherently look at as having some sort of reduced capacity, but that's not the way it's carved out in the law.
Right. It's a roundabout way, but not directly is the way that Illinois has it, which is interesting. And you would think that the way that we have reformed some of our juvenile laws recently, that may be something that North Carolina would consider at some point. I don't know.
So the other thing that courts look at, which I think is the most important, and this is, I think, the most interesting one for us because we hear about it a lot, are promises. Promises that are made. So I don't know how many times we've been on the phone with somebody and the police have talked to them, law enforcement officers talk to them and say, well, they promised me if I just say something that
this and this would
happen. Fine. Yeah, don't worry about it. There's not going to be a charge, or it's going to be a misdemeanor instead of a felony. Well, that is coercion. By the letter of the law, if police are out there promising something, law enforcement are out there promising something, that is a coercive tactic that is looked at not too favorably by the court. Now, what is important to understand about this is that as it relates to promises made by law enforcement, the reason why that is coercion is because once a law enforcement officer charges somebody with a crime, what happens with that is no longer in the control of the law enforcement officer.
Right.
It is in control of the state of North Carolina. And who represents the state of North Carolina?
The prosecutors, the district attorney's office.
Yeah. You understand that.
I understand that. I mean, there's this push and pull between district attorneys and law enforcement officers sometimes, because in even for DAs, they'll somebody will come and say, well, the law enforcement officer promised this and that, and a DA will say, well, too bad, it's the DA's case now, it's the state's case, and they're going to prosecute that case.
Mm-hmm.
And so it's important for our listeners to understand that and know that sometimes an officer might say, well, you just get an IE on this ticket, or this thing will just happen. You can't go on that because you don't know who that prosecutor is going to be. You don't know who that judge is going to be. I mean, it's just not something. Once you're charged, it's sort of out of that officer's hands and into the hands of a whole nother system. That's important, and that's important. So, yeah.
Thank you for joining us here on WTOB this morning on For the Record with Greenwood Law. We're here talking about a law that's come on the books or that's been passed in Illinois that's made it illegal for police officers to lie or coerce during an interrogation towards juvenile individuals. And Harold and I have been talking about all the different aspects of interrogations, that new law, how it might be important here coming up, how really we hope that more states pass it because it just makes a lot of sense. And then we've been talking about how these statements are viewed in the laws of North Carolina. A lot of times it gets brought up to us, people feel like when they make a certain statement or the police have said certain things to them that they were quote unquote entrapped by the police, that the police got them to commit a crime. That's the easiest way to say it. And entrapment is one of the true absolute defenses in our legal system. Other ones being involuntary intoxication, self-defense, duress, like someone put a gun to your head and told you that you had to commit a crime or else they were going to shoot you. But entrapment is probably one of the more difficult ones to prove.
It is. There's a national empirical study at the University of Pennsylvania that said that less than 0.1% of cases, the defense of entrapment was actually used, and generally that study said it was to little avail. So it is something that we hear a lot about as criminal defense attorneys, but unfortunately it's just not used very often, and there's a couple reasons why. But let's first, what entrapment actually is. It is the inducement by persuasion, trickery, or fraud carried out by law enforcement officers or their agents to induce a defendant to commit a crime. That's part one. Part two is the origin. The person has an intent or lack of predisposition that the criminal design originated in the minds of the government officials rather than the defendant. That's important because if in order to be entrapped, it can't be something you were predisposed to do. One of the ways we see this play out is a lot in prostitution type cases. I'll just be honest, that's where I've seen it play out the most. There's an interesting case, State v. Foster, out of Charlotte, and I think it's worth talking about the facts of this case. There are 3 Charlotte officers were working undercover at a male strip club, investigating complaints about business and possible drugs at the strip club. The defendant was a dancer at this club, and he and another performer gave the officers dances, and one of the officers particularly flirted with this defendant and had lots of conversation with this defendant. Eventually, the officer said, "Hey, do you have a hookup for cocaine?" The defendant said, "I do," and the officer followed up with text messages that night. The defendant didn't act on those text messages. He didn't actually respond to the officer at all, and the officer subsequently texted this guy back a week later and then asked him again about cocaine. And then the defendant, they met with the defendant at the club again. The officer gave him money. He found the cocaine for him, and he was arrested. And the issue was, at the trial, the jury was not instructed on entrapment, and the court found that was wrong, that the jury should have been instructed on entrapment. And the reason was because, according to the defendant, He didn't do drugs, but he only agreed to get these drugs on the officer's behalf because he thought that this officer had a crush on him and he wanted to impress him. And so he felt that he was pushed to get the drugs, or else the interest would have been lost by the officer. And the court found that there was sufficient evidence of entrapment. And part of it was the court looked at this in the light most favorable to the defendant, which is not something we hear a lot, that there was sufficient evidence to require an instruction, a jury instruction. So the court wasn't saying, yes, this person is absolved of this crime, but just that there's enough evidence to get a jury instruction. And that there was no evidence. I mean, part of the reason the court found that is because there was no evidence that the conversation regarding drugs was initiated by the defendant. I mean, he didn't bring up drugs. The officer brought up drugs. Not only that, the defendant ignored him, and the officer brought up drugs again a week later. And there was no predisposition evidence given by the state that this person ever used drugs. He's never been convicted of any kind of drug crime. There was never any link between this defendant and having a predisposition to do this, but for having this flirtatious relationship with the officer. Now, does that mean that that defendant would have gotten off for this? Basically, the court said remanded it and had a new trial. So I'm not exactly sure if that person got off for entrapment, but it is important to even have an instruction on entrapment because just that alone is not something that you see very often. But it is something that we hear about. So the way to think about it is if the crime is introduced by law enforcement to a person and the person doesn't have any predisposition to commit this crime, isn't in a place to commit this crime, then that would be grounds for entrapment. A lot of times we hear it used in prostitution cases where people feel that they were entrapped when, be it on either side of prostitution, by law enforcement. A lot of times that doesn't hold up. So, if someone is putting themselves out there as an escort or some sort of way like that, and then an officer comes in and generally the predisposition issue is where you find that that entrapment doesn't hold up. So yes, maybe the officer solicited that person first, but the courts are going to say, well, you were predisposed to this. Another important caveat for entrapment is that you also have to admit to every element of the crime. So you can't say entrapment exists, and I'm going to use this as a defense, but it wasn't cocaine, or it wasn't me. I wasn't the person that committed this. You sort of have to admit that yes, this crime happened, or yes, these facts happened, but I was entrapped into them. So it is a kind of a nuanced part of the law. I remember it as a bar exam question on my bar exam. So I don't know why I always think of it that way, but I would like our listeners to know that it's something that is tough to actually win in court on. It doesn't mean it's impossible, but it is just something that is not very easy to win over. A lot of times once lawyers hear or judges hear entrapment, I think people get turned off and say, oh, it's not,
Harold, I know why you remember, because when you take the bar exam, you don't ever forget that.
No, you don't forget that.
That's kind of burned into your mind. But you're right. Mere solicitation itself is not entrapment. Whenever we talk to people accused of soliciting for whatever, and it was a setup, they always bring up entrapment to us. And no, there's ample case law that says it's not. But the other things that lead to it are quote unquote setting a trap. So people brought up like speed traps and stuff before that, the officer basically set them up by being where they were. No, that's just the officer doing their job. They're allowed to, be there waiting, looking for something. As long as they're not violating some other aspect of the Constitution, that's not entrapment. The other things that get brought up are like affording an opportunity or providing a facility. So like, let's say law enforcement has access to some warehouse and they set up a deal with somebody for like a controlled buy of a substance. Again, just because they have this capability or they have access to something doesn't mean that's entrapment. If that were the case, then you would never have undercover law enforcement agents
right.
that could do their job the way they're meant to. And courts have recognized that undercover agents are a necessary part of law enforcement. So I think courts have to be careful about the line they toe when it comes to recognizing defenses of entrapment. And then also kind of what you're getting at before, if the defendant readily complies with the crime, or they allow it to complete, or something where they're disposed to do the crime to begin with, that's going to really hurt your chances of using that defense for sure.
Right. It's got to be something that you're totally you're making the argument that you were just going about your day, you're a normal citizen, and then these things happen to you, sort of, and law enforcement came on you with that. So that's the way that works. And again, that goes back to what we were dealing with juveniles. But we're thankful that you guys tuned in to For the Record with Greenwood Law. We hope that what we talked about today with interrogations with juveniles and entrapment was informative to you, and we hope that you tune in next time.
And don't forget that Greenwood Law Bill of Rights. First and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. Remember, it's not a crime to know and assert your rights. Stay safe out there. This is For the Record with Greenwood Law, signing off.